Welcome to the Courtroom Club. Today we're really digging into something important for property owners, how you legally handle evicting a tenant who isn't paying rent. We're talking about the situation in South Africa, specifically looking towards 2025. As part of the Jonker Vorster Attorneys team, well, we see this quite a bit. It's a major concern, so we want to give you a clear guide on the process, making sure you stay on the right side of the law yourself.
Exactly. And the thing is, right from the get-go, you need to understand the legal framework. We're talking about the Prevention of Illegal Eviction from an Unlawful Occupation of Land Act. Most people just call it the PIE Act.
The PIE Act.
Yeah, and it sets out a very, very specific path. You absolutely have to follow it for an eviction to be lawful. So we'll walk you through those key steps.
Okay, let's start at the beginning then. You're a landlord, your tenants stop paying. What's the absolute first move before lawyers, before courts?
Communication. Honestly, just try talking first. Have an open, frank discussion if you can. Sometimes, tenants face genuine, maybe temporary financial issues.
Right, life happens.
Exactly. And maybe a conversation leads to, say, a payment plan, something you can both agree on. If you can solve it amicably like that, fantastic. You avoid all the legal stuff. We always suggest trying that first if it feels possible.
Makes sense. Keep things civil if you can. But, okay, what if talking gets you nowhere? The rent still isn't paid.
Right. If that informal approach doesn't work, then you need to get formal. The next step, and it's absolutely crucial, is issuing a formal letter of demand. This isn't just a friendly reminder, you see. It's a legally significant document.
Okay, so what needs to be in that letter?
It has to be crystal clear. State the exact total amount of rent that's overdue and give a specific date they need to pay by. Usually that's, 7 to 14 days? Depends on your lease agreement, really.
Right, check the lease terms.
Definitely. And, very importantly, the letter must warn the tenant that if they don't pay by that deadline, you will start legal action for eviction.
So it's the formal warning shot,
Yeah.
basically. Clear consequences.
Precisely.
And if that deadline comes and goes, still no money.
Okay, if the letter of demand doesn't get a response, or they just don't pay up, then you move to the next stage. This involves formally canceling the lease agreement.
Canceling the lease itself.
Yes. You send another formal letter stating the lease is canceled due to the non-payment, and then we proceed with the court application. You apply for an eviction order from either the magistrate's court or the high court.
Okay, applying to the court, what kind of paperwork are we talking about there? It sounds like it could be a lot.
It involves pulling together several key documents, yeah. You'll need the original lease agreement, the signed one. You'll need solid proof of the non-payment. So, detailed rent statements showing the arrears are vital.
Like a clear history of missed payments.
Exactly. And copies of all your communication. That initial letter of demand, the lease cancellation letter, any emails or messages, keep everything. Legally, what we do is file a notice of motion. That's the formal court application. And it's supported by affidavits, sworn statements laying out all the facts. The court then takes that application and issues a notice to the tenant. It tells them about the eviction application and gives them a date to show up in court if they want to fight it, to oppose the application.
Got it. So the court looks at everything submitted. Assuming it all checks out, what's next?
Well, if the court agrees that your application is valid, and importantly, that you followed the PIE Act procedures correctly.
Which is what we're outlining now.
Right. Then the court will issue a formal eviction order. And this order is specific. It states a date by which the tenant legally must leave the property.
Okay, a court order. That sounds pretty final. But
Yeah.
what if they still don't leave, even with that order?
Yeah, that can happen. And that's when the sheriff of the court gets involved. Their job is to enforce the court's order. This might mean, unfortunately, the sheriff physically removing the tenant and their belongings from your property.
Wow, okay.
But here's the critical point for landlords listening. Never, ever try to remove the tenant yourself. Don't change locks, cut off utilities, none of that. Not without that court order being enforced by the sheriff.
Why not?
Because that's illegal self-help eviction. It's unlawful, and you, the landlord, could face serious legal trouble. Fines, even potential damages claims from the tenant, it backfires badly.
Good warning. So, always through the official channels, sheriff included if needed.
Always.
Now, sometimes things feel really urgent. Maybe the property's being damaged or something else serious. I've heard about an urgent eviction order. Is that a real option?
It is a real thing, yes, but let me stress it's very limited. It's reserved for truly exceptional, serious situations.
Like what kind of situation?
Typically, it's where the tenant's presence or actions pose a real imminent risk. Maybe a threat to public safety, significant ongoing damage to the property, or perhaps serious illegal activities happening there.
Okay, so not just because the rent is late.
Definitely not. While an urgent order can be quicker, the legal bar to get one granted is incredibly high. You need very strong evidence. Success is honestly quite rare without that compelling proof and, frankly, expert legal help. It's absolutely something where you must consult experienced attorneys first, like us here at Jonker Vorster. We can assess if your situation even potentially qualifies before you go down that road. It's complex.
Okay, so urgent orders,
Mhm.
possible, but difficult and for extreme cases only.
Got it. Beyond the steps themselves, what other sort of overarching legal points should landlords keep front of mind?
Well, we keep coming back to it, but the PIE Act is absolutely central. It dictates everything. It forces landlords, us, to follow this correct legal process we've been talking about. You must get that court order before removing anyone. And it also emphasizes giving the tenant proper notice at each stage and a fair chance to respond. The courts look very closely at whether the process was fair to the tenant.
Procedural fairness is key.
Hugely important. And linked to that is documentation. I know I mentioned it for the application, but really document everything from day one. Keep copies of the lease, meticulous payment records, notes of conversations, copies of all letters, emails, everything. This paperwork is your best friend if things end up in court. It strengthens your case immensely. Makes sense. Are there common mistakes you see landlords make? Things people should actively try to avoid?
Oh, absolutely. The biggest one, we've already hit hard, is attempting self-help eviction.
Yeah.
Changing locks, cutting off water. Just don't. It's illegal and will cause you massive problems.
Right. Number one mistake.
Number one by far, other common pitfalls, failing to give the correct legally required notice periods or sending notices that aren't properly worded according to the act. Also, having incomplete documentation. If you can't prove the arrears properly or can't show you sent the notices correctly, your whole eviction case can fall apart or face huge delays. It's about being thorough.
This whole process, even done correctly, sounds like it might take a while. What's a realistic time frame a landlord should brace for?
Yeah, it's usually not quick. The timeline can really vary quite a bit. You're typically looking at somewhere between, say, 3 months on the very fast end up to maybe 12 months or sometimes even longer.
Well, up to a year. What makes it vary so much?
Several things. The court's own schedule and backlog is a big factor. If the tenant decides to actively oppose the eviction, that adds time hearings, potentially more paperwork, and just the general complexity of the specific case. Are there disputes about the lease terms? Are there dependents, like children, involved? The court considers all circumstances.
So patience is needed.
Patience and acting promptly yourself. Starting the process correctly as soon as it's clear communication has failed and making sure all your ducks are in a row procedurally, that can help avoid unnecessary delays at least.
Okay. And what about the elephant in the room, the cost? What kind of expenses should a landlord anticipate?
Costs also vary, naturally. You've got court filing fees, which depend on whether you're in the magistrates or high court. Then there are legal fees if you hire attorneys, like our team, to handle the process for you, which, given the complexities, is often advisable.
Probably wise.
And then you have the sheriff's fees. They charge for serving the documents on the tenant, and then again, if they actually have to carry out the physical eviction. It's definitely best practice to have a frank discussion about potential costs with your legal team right at the start. We always aim to give clients a clear picture of the likely financial side.
Good advice. Get clarity on costs up front. So let's sort of wrap this up. What we've laid out is that evicting a tenant for non-payment in South Africa, looking at 2025, it's a very structured legal process. You absolutely have to follow the PIE Act. It involves steps like trying to communicate first, then the formal letter of demand, then the court application, getting that order, and potentially needing the sheriff.
Exactly.
And trying to cut corners, do it yourself. That's a recipe for legal trouble for the landlord.
Yeah, absolutely. And you know, what's interesting is, while it might seem like a long and complicated road, understanding each step, being meticulous with your paperwork that's actually your strongest position, it's not just about getting your property back, though that's the goal. It's about doing it lawfully, upholding the process, and protecting your own rights within that legal framework.
Well said. And of course, if you, the listener, are facing this kind of difficult situation, remember that this is exactly what we specialize in at Jonker Vorster Attorneys. Evictions, landlord-tenant law. Our team has the experience to guide you through it properly, support you, and make sure your interests are protected legally. So please, do reach out if you need professional help. Now, just as a final thought for you, the property owner listening, We've talked a lot about the eviction process itself, the cure, if you like. But maybe think about prevention, too. What proactive steps could you build into your lease agreements from the start, or into your tenant screening process? Things that might help reduce the risk of non-payment happening in the first place, potentially avoiding this whole difficult process altogether. Something to mull over.